The admission clause, common interpretation by Eric Biber and Thomas B. Colby. This clause affords Congress the power to admit new states. Most discussion in the Constitution Convention focused on the latter, limiting portion of the clause providing that new states can be carved out of or formed from existing states only with the consent of those existing states. Some convention delegates object to this provision on the ground that because several of the existing large states laid claims to one-twentieth of Western territories and other lands, those states would never consent to form new states in those territories, and thus the large states would only become larger and more powerful over time. But the prevailing sentiment of the convention was that a political society cannot be split apart against its will. While the consent requirement garnered the most discussion and the framing has come into play only a handful of times in American history, such as when Massachusetts consented to the formation of Maine. Most intriguingly, Virginia was treated as consenting to the formation of West Virginia and the outset of the Civil War, even though it was actually a breakaway pre-Union province of Virginia that declared itself to be the lawful government of Virginia and then purported to give Virginians consent to the creation of the new state of Western Virginia, which was to occupy then the same breakaway corner for Virginia. The opening portion of the clause granting Congress the general power to admit new states and played a far more significant role in American history. Only 13 states ratified the Constitution pursuant to Article 7. All of the remaining 37 states were subsequently admitted to the Union by Congress pursuant to this power. This power is thus an important one, and yet the Constitution provides almost no guidance as to how Congress should exercise it. Nor does the Constitution impose any other express limits on it. Neither is there such much guidance in the framing history about its meaning or scope. Accordingly, much of the practical meaning of the admissions clause must be drawn either from case law interpreting the clause or from the practice of Congress in admitting states, beginning with Vermont in 1791 and ending with Alaska and Hawaii in 1959. New states have generally been admitted after a period of territorial government during which Congress, the President, had the broad authority pursuant to the Property Clause, also in Article 4, Section 3. An act of Congress establishes territorial government, often giving greater self-government, that is, in the form of elected territorial legislature, as the territory's population increased over time. Some states, however, such as California and Texas, have been admitted without even ever being territories. The admissions clause provides that admission of a state requires at least one act of Congress. However, Congress has often followed a more complicated process. For many admitted states, Congress first passed an enabling act, which authorized the population of territory to convene a constitutional convention to draft a constitution for the new proposed state and to apply for admission to Congress. In the Enabling Act, Congress specified a range of conditions that the proposed state had to meet in order for admission to occur. These conditions varied widely across time and the states. For example, some states were precluded from allowing polygamy or slavery, and some states were forced to practice religious toleration or to afford civil jury trial rights. Once the proposed state constitution was drafted, it was sent to Congress, which then decided whether to pass an additional act or resolution at a meeting in the state. One variation in the Enabling Act process involved Congress delegating the final approval process to the President. The primary issue that the courts have wrestled with pursuant to the Administrations Clause is the extent to which it limits the power of Congress to impose the aforementioned conditions on or otherwise to limit the sovereignty of admitted states. Even though the Constitutional Convention rejected a provision requiring Congress to admit all new states on an equal footing with the original states, thus seemingly leaving the issue to the discretion of Congress, the Supreme Court had nonetheless read such a requirement into the Administrations Clause. And Congress, despite its frequent imposition of conditions, has in fact included language in virtually every state's admission act providing that the states is admitted into the Union on an equal footing with the original states in all respects whatsoever. The equal footing doctrine was first constitutionalized in Pollard's Lease versus Hagan, 1845, where the Supreme Court held that as a matter of basic sovereignty, all states have ownership of the beds of the navigable waterways, submerged lands under major rivers and lakes, and thus because newly admitted states must be on an equal footing with existing states, newly admitted states obtain the same ownership rights when they join the Union. Most famously, the Supreme Court applied the equal footing doctrine in Coyle versus Smith, 1911, to strike down a condition in the Oklahoma Enabling Act that restricted the ability of the newly admitted state to move the location of the state capital. The court held that since Congress would not have the power to restrict an existing state's decisions about where to locate its state capital, under the equal footing doctrine, Congress could not control where the newly admitted state could locate its state capital either. The equal footing doctrine applied only to matters of state sovereignty authority, not to economic, geographic, or ecological conditions, and nonetheless may give some states more resources than other states. For instance, the fact that the federal government owns more than 80% of the land in Nevada does not mean that Nevada was not made on the equal footing with other states, such as in New York, where the federal government owns less than 1% of the land. United States versus Gardner, 9th Circuit, 1997. Nor does the equal footing doctrine require the federal government to surrender ownership of lands it owns within the newly admitted state, and does not affect the broad power that the federal government has to regulate those lands under the property clause. Now matters debate the first perspective, the nature and the scope of the equal footing doctrine by Eric Biber. By far, the most important aspects of the Administrations Clause in terms of constitutional law is the Supreme Court's articulation of the equal footing doctrine. The Court first developed the doctrine in the mid-19th century in Pollard's Lease versus Hagan, 1845, but over the following century and a half and more, it is fair to say that the doctrine has inspired far more controversy and debate outside the courtroom than it ever has in terms of judicial interpretation and the precedent. When we focus strictly on the Court's case law developing the doctrine, it has relatively limited scope. The court has stated that the equal footing doctrine does not prevent Congress from imposing conditions on the admission of new states so long as Congress would have the power to impose those conditions under another clause of the Constitution separate from the admissions clause. Accordingly, the courts have upheld conditions in state enabling acts that restrict the whole state's use of public lands that were given by the federal government to the states to support state schools because Congress would have the power anyway under the property clause. See, for example, ESERCO, that is ARSACO, incorporation was Kaddish, 1989. Similarly, lower courts have regularly concluded that the doctrine does not require that states be equal in any sense other than in core attributes of sovereignty. The doctrine does not implicate questions of economic or effective political power. It's irrelevant for the doctrine that most of the land in states such as Nevada is owned by the federal government, but there is very little federal land ownership in the states like New York. It is also irrelevant for the doctrine that as a result of the Supremacy Clause and Congress's power to legislate for federal lands under the Property Clause, the federal government effectively has much more regular authority in the states like Nevada than it has in a state like New York. Nonetheless, political activists, state, local elected officials, and others have argued strenuously at times that the equal footing doctrine requires the federal government to transfer ownership of its public lands in western states so that the states can truly be on an equal footing. All of these calls have been squarely rejected by the courts. Indeed, language in the Supreme Court's opinion in Pollard's lease that implied that the equal state sovereignty required the transfer of federal public land ownership to states upon admission by the Union has been effectively overturned by decades of subsequent Supreme Court and lower courts precedent. The debates over federal land ownership which have recurred over the decades reflect a key fact about the admission clause. Much of its importance for our constitutional system of government is reflected in how it is being implemented in practice, not just in the constitutional legal principles developed by courts. Thus, despite the existence of the equal footing doctrine and its articulation by the Supreme Court over many years, when new states were admitted to the Union, Congress continued to regularly impose conditions on newly admitted states. They imposed significant constraints on their political systems and structures. For instance, when Louisiana was admitted as state in 1812, it was required to guarantee jury trials, bail in all criminal cases and to use English in all official states' publications. 100 years later, contemporaneous with the Supreme Court decision on Coyle versus Smith, 1911, Congress required New Mexico to use English in its public schools and to require all public officials to speak English. Southern states readmitted during Reconstruction were required to protect the suffrage of freed slaves. When admitted in 1896, Utah was required to prohibit polygamy. What these conditions all similarly reflect is a suspicion by the admitting Congress that the new states could be loyal members of the Union and would assimilate into the dominant political values of the American Republic. In turn, Congress was suspicious of the loyalties of the French and the Spanish Catholic settlers in Louisiana, of residents of Spanish and Mexican descendants in New Mexico, of recently rebellious whites in southern states after the Civil War, and for Mormons in Utah. Moreover, regardless of the extent to which the court, as a matter for case law, imposed limits on admissions conditions pursuant to the equal footing doctrine, Congress imposed significant constraints on newly admitted states, and the process of admission Subject to these conditions often, though not always, led to substantial assimilation by the newly admitted states. English and American common law traditions came to take a leading role in Louisiana politics and law. Mormons in Utah abandoned polygamy. The history of the decidedly unequal relationship between Congress, the newly admitted states, and the continued unequal distribution of federal public lands and the Salt City Federal Regulatory Authority show the limits of the equal footing doctrine. That is not to say that the doctrine is not important. It is surely important that the Congress cannot use its admission clause powers to force the newly admitted state to only accept one senator and the representation in the Senate. But the nature and the form of our current constitutional system is just as much shaped by the practice Congress uses for the admission clause as it is by the case law of the equal footing doctrine. A separate question that is raised by the equal footing doctrine is the extent to which the equal footing doctrine might reflect a fundamental constitutional requirement that all states be treated equally by Congress with respect to certain core areas of sovereignty, regardless of whether Congress acting in connection with admission of a new state or not. In Shelby County versus Holder, 2013, the Supreme Court struck down a portion of the Voting Rights Act that imposed specific procedural requirements on certain states that sought to change their election laws. The court reasoned that this kind of differential treatment of states infringed on an obligation that the states have equal standards in certain core matters of sovereignty, and it cited Coyle v. Smith and the equal footing doctrine to support its reasoning. The court conclusion has been the subject of sharp criticism. See, for example, Zachariah S. Price, Newman's non-existing principle of state equality. So the extent to which this new principle will continue to be embraced by the court and its future scope are yet to be determined. The next perspective, the admissions clause and the equal sovereignty principle by Thomas B. Colby. In Shelby County versus Holder, 2013, the Supreme Court cited the equal footing doctrine case in support of its assertion that there is a fundamental principle of equal sovereignty among states. But the core application of the equal sovereignty principle to strike down part of the Voting Rights Act in Shelby County was dubious. Its basic assertion was correct. The admissions clause empowered Congress to make new states into this union, as Senator Trumbull explained in 1870. These words implicitly reflect a fundamental constitutional principle of equal state sovereignty. The state which formed this union were called equal states. Congress has authority to make new states into the union. Into what union? A union of co-equal states. There is no authority to make these states into any other union. You have a different union if you have a union of unequal states. The court made this same point in Coyle v. Smith, 1911. But what is this power? It is not made political organizations which are less or greater or different in dignity or power from those political entities which constitute the union. The power is to make new states into this union. This union was and is a union for states, equal in power, dignity, and authority. To maintain otherwise would be to see that the union through the power of Congress to make new states might come to be a union for states unequal in power. The admissions clause equal footing doctrine is therefore a specific manifestation of a general constitutional principle of state sovereign equality that is necessarily implied and guaranteed by the very nature of the Federal Compact. Withers versus Buckley, 1857. As one federal court put it in the late 19th century, the doctrine that a new state must be admitted on the equal footing with the old ones rests on what is considered to be the general character and the purpose of the union of the states, a union for political equals. Case versus Tofts, 1889. Or in the Supreme Court's words from Withers, the perfect equality for all the members of the Confederacy with regard to their attributes and independent sovereign governments follows from the word nature and objects of the Confederacy and from the language of the Constitution. From Coyer, the constitutional equality of the states is essential to the harmonious operation of the scheme upon which the Republic was organized. When that equality disappears, we may remain a free people, but the Union will not be the Union of the Constitution. As such, while the admission clause, equal footing doctrines themselves concern only the admission of new states, the equal sovereignty principle upon which the equal footing doctrine is based is much broader. Equality of constitutional right of power is the condition of all the states of the Union, old and new. Is Kanaba Corporation versus Chicago, 1883. There can be no distinction between the several states' union in the character of the jurisdiction, sovereignty, and dominion, which they may possess and exercise over persons as subject within their respective limits. Illinois Central Railroad Corporation versus Illinois, 1892. Thus, per its Congress, even when it is exercised its legitimate powers, is constrained to respect constitutionality, manages sovereign equality for all the states. Congress cannot use its power in a way that affords more sovereign authority to some states than to others. The whole federal system is based upon the fundamental principle of the equality of the states under the Constitution. The idea that one state is debarred by Congress, while the others are granted the privilege of amending their organic laws to conform to the wishes of their inhabitants, is so repugnant to the theory of their equality under the Constitution that it can be entertained. Bolin versus Nebraska, 1900. This axiom was born of history, and the Constitutional Convention, the notion of equal sovereignty consistently held center stage. The small state delegates in particular insist as a part of their demand for equal representation in Congress that, as William Patterson put it, a confederacy supposes sovereignty in the members composing it, and sovereignty supposes equality. The large state delegates did not disagree with the notion of equal sovereignty. They disagreed instead with the insistence that the equal representation was necessary for equal sovereignty. They felt that as long as each state conceded the same authority to the federal government, the states would maintain equal sovereignty regardless of the measure for representation in Congress. Hugh Williamson, for instance, expressed the view that if the states were equal sovereign now and parted with equal proportion sovereignty, and then they would remain equally sovereign. The ultimate decision to afford the state equal representation in the Senate, a partial victory for the small states, was explicit reflection of the equal sovereignty principle. And James Madison put it in the Federalist number 39, the Senate will derive its powers from the states and the political and co-equal societies, and this will be represented on the principle of equality in the Senate. Madison explained, and the Virginia Ratifying Convention, that the Constitution created a government of a federal nature consisting of many co-equal sovereignties. As such, Madison later wrote, it's constitutionally impossible for Congress, whether it is dealing with new or old members of the Union, to vary the political equality of the states. That principle has not changed in the intervening years, though Congress should be afforded some levy to deviate from the equal sovereignty principle when acting pursuant to its Reconstruction Amendment enforcement powers. The Civil War and Reconstruction did not abolish the fundamental constitutional principle of equal sovereignty. Indeed, COIL and most of the other equal footing cases post-date Reconstruction. But then John Bingham, Panmure Reconstruction era's most influential legislator, explained, equality to men and the states before the law were the watchword, the central informing vital thoughts of the Republican Party. And both the outset and the close of the war, the North insisted that the entire purpose of the war has been to preserve the Union with all the dignity, equality, and the rights of the several states unimpaired.